This is Dr. Mark Leiser from the Riga Graduate School of Law and a technology law consultant at DigiData Consulting Limited. I've decided to do a series of 5 lectures on why I think the Digital Omnibus is so important. This is the first of those 5 lectures. I want to start with the big picture. The Digital Omnibus can look like a technical exercise in tidying up European digital law, but it's much more consequential than that. It asks who decides when the GDPR applies, how reliably organizations can act on that decision, and whether Europe's expanding digital rulebook can function as a coherent legal system. My central claim is simple. The GDPR now acts as the hinge of the European digital acquis. If that hinge is unstable, friction travels through AI, research, data sharing, digital health, cookies, and the wider European data economy. Let me give you an example about what I'm talking about. Imagine a hospital creates a coded neurological data set. The hospital keeps the key that links each record to a named patient. It transfers the coded records to a European research consortium under a strict governance agreement. The consortium has no key, no lawful route to obtain it, no additional identifiers that would let it reconnect the records to named patients. The information hasn't magically changed during the transfer. The actors, their capabilities, their purposes, and the safeguards have changed. For the hospital, the records are plainly personal data. No complaint there. For the constrained consortium, the answer requires a contextual assessment. That difference affects the consortium's research design, its legal basis, its governance, any AI development, and the conditions under which results may enter a European data space. This hypothetical captures the omnibus dispute in miniature. Should legal status attach permanently to the data because somebody somewhere can identify the person? Or should the law also ask what the particular actor can realistically do? A sound answer must recognize genuine removal of identification capability without allowing organizations to manufacture artificial separations to escape responsibility. That is the line that the legislation has to draw. Before going further, we need to separate 2 files that are easy to confuse. The general Digital Omnibus is the broad data law proposal. It contains proposed changes touching the GDPR, ePrivacy, and other parts of the digital acquis. In the report that I've written's legal snapshot, the file was not law. It had no Council general approach, no Parliament negotiating mandate, no interinstitutional agreement. The separate Digital Omnibus on AI occupied a different position. Regulation 2026/1744 completed the legislative process and entered into force on the 27th of July 2026. One omnibus had therefore moved into implementation, while the wider data law file remained politically open. That distinction is not procedural trivia. It prevents draft compromises, presidency texts, and committee amendments from being presented as existing obligations. Throughout this lecture, political statements refer to the legislative position at the 31st of July 2026, while the public sources I have checked until the 19th of August. The general omnibus was a live opportunity for settlement, not a settled body of law. So let's start with the definition. A gold Article 4 trigger ring is surrounded by the consequences that follow when the GDPR overlay engages. Article 4 tells us what personal data is, or are. Read with the GDPR's material scope and processing rules, that definition acts as a switching rule. Once information qualifies as personal data for the relevant actor and processing context, the GDPR overlay engages. That overlay includes questions of lawful basis, transparency, data subject rights, accountability, security, governance, enforcement, and penalties. The provisions do not all apply identically in every case, but the classification determines which legal architecture the organization must enter. This is why apparently small disagreements over identifiability carry large consequences. If the threshold is too loose, organizations can evade duties through nominal separation. If it's too broad or too uncertain, privacy-preserving recipients remain trapped inside a regime designed for actors that retain realistic identifying capability. Article 4 is therefore not merely a glossary entry. It determines when the extensive system wakes up, for whom, and on what evidence. Europe has built an extensive digital rulebook around the GDPR. We now have the AI Act, the Data Act, the Data Governance Act, the Digital Services Act, the Digital Markets Act, the European Health Data Space, Common European Data Spaces, and of course the ePrivacy Framework. All of these instruments do different jobs. The AI Act governs risks across an AI system's life cycle, for example. The Data Act structures access and use. The European Health Data Space creates control routes for health data reuse. Article 5.3 of the ePrivacy Directive protects terminal equipment like your mobile phone, yet each regime repeatedly encounters the same prior classification question. Are the information and processing activities personal data for the actor concerned? This makes the GDPR the hinge. If the answer is yes, duties accumulate across the regimes. If the answer is no for that actor and context, adjacent legislation may operate without the full GDPR layer. An unstable hinge produces repeated classification work, duplicate safeguards, divergent enforcement amongst the member states. The Omnibus is therefore not merely a privacy file or a data protection file. It's a regime coherence file for the entire digital acquis. And you might be surprised to learn that the GDPR did not begin from the premise that rights protection and data use are mutually exclusive. Article 1 protects natural persons and also safeguards the free movement of personal data within the Union. The regulation's architecture reflects that dual purpose. Recitals 74 to 76 focus on likelihood and severity of risk. Articles 24, 25, 32, and 35 calibrate responsibility, design, security, impact assessment to context. High-risk processing attracts stronger safeguards. Lower-risk processing still attracts duties, but those duties should remain proportionate to the risks that the activity actually creates. This is a regulatory dial rather than a switch left permanently at maximum precaution. The distinction does not weaken fundamental rights. It concentrates legal attention where identification, intervention, and harm are realistic. The AI Act uses a comparable structural idea when it differentiates obligations by risk rather than treating every AI system alike. The omnibus debate should therefore start with the GDPR's own design. The question is not whether Europe should replace protection with economic expediency. It's whether a risk-based regulation still distinguishes meaningfully between actors, contexts, levels of risk. Equal protection does not require uniform regulatory intensity. The difficulty is that parts of the system have drifted away from this calibrated model. The drift does not require a deliberate plan. It can emerge from the interaction between open legal language, severe potential consequences, and uncertainty about enforcement. A supervisory authority publishes a cautious interpretation. Lawyers and auditors advise organizations to follow it. Product teams and investors treat it as the safest benchmark. A later authority begins from that market practice when assessing compliance. Each step looks defensible on its own. Together, the steps create a one-way ratchet. The practical perimeter expands, while organizations lack an equally reliable route for proving that privacy-preserving architecture has reduced risk enough to change legal status. Return to the research consortium. If technical separation, legal restrictions, absence of a key, and independent testing create no dependable legal consequence, the consortium has little incentive to invest in them. It may classify every stage as fully identifiable personal data, narrow the study, or abandon the collaboration altogether. That is regulatory inflation. Lower risk and higher risk activities begin to attract similar defensive responses, not because the legislator enacted that result, but because uncertainty rewards the strictest credible interpretation. An unstable trigger does not create a single compliance cost. It recreates the cost at every legal interface. The consortium first classifies the data under the GDPR. It then asks how that classification affects AI deployment, health data reuse, data space access, terminal equipment rules, and sector-specific obligations. Legal uncertainty becomes delayed contracting, duplicated governance, narrower research design, and technical systems built around the strictest conceivable interpretation. Large organizations can absorb more of that cost. They can retain specialist teams, maintain alternative architectures, and litigate. Smaller firms, hospitals, research groups, downstream providers often delay, withdraw, or move activity away from the legal margin. That outcome does not necessarily reduce risk. It can discourage the measures that actually remove identification capability, like secure environments, architectural separation, strict access controls, aggregation, differential privacy, and enforceable restrictions. Europe's digital strategy assumes that rights protection, data availability, and innovation can coexist. That assumption requires safeguards to produce a legible legal effect, rather than another layer of documentation with no reliable consequence. This structural problem is now part of a live political file. The Commission presented the General Digital Omnibus on the 19th of November 2025. It sought greater legal clarity, lower administrative burden, and better coherence across the digital framework. The Council process did not then move in a straight line. The Cyprus presidency could not secure support for a compromise that removed important operative provisions and returned much of the practical work to the EDPB guidance. The blocking group formed a negative coalition. Several member states agreed that the Cyprus text delivered too little simplification, but they could not agree on one replacement package. The Irish presidency used that opening to reset the discussions. Its questionnaire returned to synonymization, AI processing, cookie consent, and compliance burdens. At the 16th of July working group meeting, governments tested four negotiating clusters: identifiability and synonymization, AI development, compliance burdens, and ePrivacy exemptions. The discussion revealed issue-specific coalitions rather than simple rights versus reform divide. Some states resisted reopening Article 4, but supported an operative Article 29A route. Others wanted binding criteria or Commission implementing measures rather than the EDPB guidance alone. Parliament, meanwhile, remained in its amendment and impact assessment phase. The failure of the Cyprus text therefore created a drafting window, not a victory for either side. The report, I write, identified the 11th September Council Working Party meeting as the next procedural test. The resulting choice has three dimensions. The first is substance. Should the law recognize actor relative identifiability, and which anti-circumvention safeguards should surround it? The second is legal vehicle. Should the rule sit in Article 4, in a new Article 29A, in a recital, or in some combination? The third is institutional authority. Should the essential criteria appear in legislation, Commission implementing acts, or EDPB guidance? Those choices are not interchangeable. Primary legislation offers democratic settlement and clearer legal consequences, but it must leave room for technical evolution. Implementing acts can provide binding detail and judicially reviewable consequences, but they cannot be allowed to determine the essential elements that belong in the basic act. EDPB guidance provides expertise and adaptability, but non-binding text does not create a dependable reliance mechanism merely because markets treat it as a benchmark. The central institutional question is therefore who determines the GDPR's practical perimeter. Guidance can and should operationalize a legislated threshold. It should not become the sole source of the threshold's decisive content. The political argument is not simply reform or no reform. It's an argument about substance, legal form, and accountable authority. The public debate often presented two positions. One says that any clarification narrows rights and opens loopholes. I have a problem with this argument largely made by Edry and their representative. I think it's a complete falsehood. The other says that the GDPR blocks innovation and should simply retreat. Not buying that either. Neither offers a credible settlement. The Commission identified real problems but part of its proposal needed stronger guardrails. The Cyprus direction then moved too far the other way by deleting legislative answers and relying more heavily on recitals, opinions, and guidance. My report argues for a third route. First, put contextual identifiability into binding law. The test should examine the actor's actual technical, organizational, and legal capabilities. Second, preserve responsibility for outsourced identification, processors, affiliates, artificial separation, and realistic onward transfer. Third, create usable assurance. A documented assessment, approved method, or certification should produce a rebuttable legal consequence, not immunity. Concealed facts, changed capabilities, or deliberate re-identification would defeat it. Fourth, discipline institutional power. Supervisors should provide methods, evidence, and consistency within the legislated perimeter under duties of cooperation and reasoned decision-making. The same structure supports targeted reforms elsewhere, a bounded route for incidental special category data in AI, coherent rules for meaningful human intervention, harmonized research conditions, a low-risk ePrivacy whitelist, and a safeguarded AI development pathway. That's not simplification at the expense of rights. It's the precision in the service of rights. Strong protection requires a clear and enforceable perimeter that attaches where identification, intervention, and harm are realistic while rewarding demonstrable removal of capability. The rest of this series follows that argument in sequence. Lecture 2 asks, personal data for whom? It examines Article 4 after the EDPS versus SRB case, the EDPB's anonymization guidelines, and the safeguards needed to stop contextuality becoming a loophole. Lecture 3 turns to the GDPR's internal boundary. It asks when inference, residual sensitive data, AI training, and automated decisions should intensify protection under Article 9 and 22. Lecture 4 follows the friction across research, cookies, European health data space, and common data spaces. It separates terminal integrity from downstream personal data processing and asks where low-risk exemptions belong. And Lecture 5 returns to institutional power. It asks who should write the perimeter rules and sets out the report's legislative settlement, including assurance, a duty to cooperate, and a bounded innovation mandate. The 5 lectures build one cumulative claim. Europe needs stable triggers, proportionate duties, and accountable institutions if its digital laws are to protect rights as a coherent system. The central idea from this first lecture is that the Digital Omnibus is not mainly about reducing the number of rules. It's about making Europe's expanding digital rulebook operate through stable triggers, proportionate obligations, and democratically legible choices. That returns us to the coded neurological record from the beginning of the lecture series. The hospital holds the key. The consortium does not. The information is the same. The realistic capability is different. Can the data therefore remain personal for the hospital while occupying a different legal position for the constrained recipient? If so, whose means count? What evidence is enough? And which safeguards prevent evasion? Those questions sit at the center of the EDPS versus SRB case and the present anonymization debate. They are the subject of Lecture 2, Personal Data for Whom? In the next lecture, I turn to the question on which the whole reform pivots. When is the same synonymized dataset personal data for one actor, but not for another? Continue to Lecture 2, Personal Data for Whom?